during a civil trial in New York, in a medical malpractice case, an accident case, or even a wrongful death case, can an attorney make objections during closing arguments? Would you like to know the answer? Come join me for a walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. The answer is yes. An attorney can make objections during closing arguments. Is it done? The answer is yes and also no. There are two parts to that answer. The first part is generally and typically, or I should say customarily, attorneys are not going to make objections during closing arguments. Why? So as not to interrupt their opponent. That's number one. Number two, if the comments that are being made by the opposing lawyer are offensive, if they are clearly objectionable, if there is no basis for them to make it, or they are commenting on something that never should have been talked about, then the opposing lawyer has an obligation to his client to stand up and yell out objection. The drawback, there is a drawback to doing that. The drawback to making an objection during the course of closing arguments is that the jury, in all likelihood, may not truly understand what it is that the attorney is objecting to and why. They may be falling asleep. The jury may be bored. The jury may not understand the significance of what the opposing lawyer just said. And by making an objection, now what you are doing is calling attention to that very issue. And now you give the defense lawyer or the opposing attorney an opportunity to explain, because as soon as the attorney makes an objection, the judge is going to want to know what the problem is. What's the objection, counselor? And now in a very brief explanation, you have to tell the judge what the problem is. However, the judge then turns to the opposing lawyer and says, okay, what do you have to say about that, counselor? And now it gives the opposing lawyer an opportunity to actually explain and to delve further into why he was saying those things. So what you are doing when you make an objection is you are now drawing attention to that particular offensive comment, and you give the opposing lawyer the opportunity to explain to the jury and to reinforce what he just said. So many times the better practice is to simply ignore it, to not say anything, to sit there quietly, to let it go over the heads of the jury. Why? When the lawyer who has made these offensive comments sits down and finishes his closing arguments, now the attorney, your attorney, will have an opportunity to get up and go ahead and make his own closing remarks. And he will be able to comment on anything that the opposing lawyer has said. He'll be able to comment on any of the evidence. He'll be able to touch upon anything that was inappropriately done during the course of trial. And the defense lawyer, the opposing lawyer, will not have an opportunity to say anything else. Why? Because he's not going to object to the opposing lawyer objecting or commenting on inappropriate things that he did. That's why. So, why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases, these accident cases, and even these wrongful death cases here in New York. You know, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.